This is the final chance. In other words, anything that you're very desperate to get out but had no opportunity to get out or doesn't fit into the agenda, it's the final opportunity to get them out. So first session, Brian, is it? Okay, Brian.
Testing. Yes, so I'm responsible for the new and remaining concerns with Article 23 legislation. Emerging from the discussion, there are two particular aspects of development since the failed attempt to legislate Article 23 in 2003. First, the difficulties regarding trust between the key players remained unresolved, if not worsened. Although the general public maintains confidence in the judiciary, the general trust between HK and PRC has deteriorated, as well as the confidence of the public in the law enforcement agencies in exercising its powers in relation to prosecution and investigation. Second, there are observations that prominent mainland officials are increasingly vocal and interventionist in commenting on policies and enforcement of law in Hong Kong, especially in matters perceived by PRC as relating to national sovereignty. This adds to the first aspect that exacerbates the concerns attached to the potential implementation of the Article 23 legislation, whether or not enacted in the form of the revised bill in 2003. From the written submissions and the discussion, it is clear that some forms of protest, such as the umbrella movement, may be protected by some defenses which would otherwise incur criminal liability under the revised bill. Nevertheless, during the discussion, many expressed the view that even if the drafting of the substantive offences in the legislation is clear and confined, the primary concern lies with how the law is actually applied in practice, especially at the stage prior to prosecution by the law enforcement agencies. This is echoed by the experience in other jurisdictions, such as India, where many activists were detained and arrested without charges being pressed, and in any event, a very small proportion of them would eventually be convicted. In relation to this concern, references were made to the pre-existing wide police powers under the Crimes Ordinance, as well as under the original or revised bill in 2003. There are also references as to certain measures, such as prescription of organizations that enable the government to intervene at the stage before the ordinary inchoate offences come into being. Apart from the observation that such measures would likely be ineffective in its aim to suppress undesirable expressions, these wide powers of restriction could be exercised before and without the court giving a final judgment on a substantive offence under Article 23 legislation. Any comments by prominent mainland officials on the protests or expressions might influence prosecutorial decisions would exacerbate this concern. These combined together are likely to hamper the environment in which freedom of expression, assembly, and demonstration is exercised. These would potentially include the expression of dissent on the internet, such as on social media platforms. Last but not least, it is observed that Macau has enacted local legislation in 2009 to implement the Article 23 in its basic law, which is identical to the Hong Kong counterpart. Although there has been no prosecution under the Macau legislation, there is expression of concern towards the use of existing laws and policies to achieve the same effect. Certain measures, such as the need of prior notification for seminars on One Belt, One Road, the prohibition of entry of academics without justification, and the detention of peaceful activists are alarming. How the existing laws interact with the pursuit of national security objectives and the impact on fundamental rights should be one of the factors to be considered in relation to future enactment of Article 23 legislation.
Simon, you chaired that session. Did you want to add anything? Did you feel it pretty much covers it? I think the goal is, if people have colleagues have something to add that they can think of, we can add it right away. But I understand that Cora will also circulate this among us. So at that point, you would have a chance to maybe reflect on it more than you can just listening now. But if there's something that anybody want to add to, if we're talking about the first session, then please.
Ask to strike out the One Belt, One Road, because in the end of the day, I didn't go deep why they were, what is the reason why they asked us to inform, and they didn't declare expressly that, okay, look, you have to inform, we have to authorize. They never said it, so I would,
So it's just a part.
Yeah, One Belt, One Road, yes.
All right.
Because it could be because it's related to foreign affairs, could be because, maybe something that touches theft of secrets, but who knows? It's just speculation at this point. I didn't go deep.
Thank you.
Hugo, sorry, any other?
Okay, the second session then.
Hugo and Tim.
Okay, testing. Okay, Tim and I are responsible for the second part, which is the mitigation of the concerns of the Article 23 legislation. And today, our participants have discussed some methods to mitigate the concerns. First, we discussed that we may use some drafting techniques, such as explicitly implementing the ICCPR into the local legislation. However, we also suggest that it's unlikely that the Hong Kong government will consider doing so and allowing such a proposal. And apart from that, we also suggest that the Law Reform Commission or just a group of academics from university can draft a fresh bill and propose it to the Hong Kong government. And this can ensure that the new proposed bill will be consistent with the international standards, such as the Johannesburg Principle. However, the Commission or the academics may be regarded by most of the Hong Kong people as the culprits of pushing forward the Article 23 legislation. And even though they may have good faith for reaching consensus, it is unlikely that the Hong Kong people and the media will trust them. Also, since the national security law has already been passed in Macau in 2009, it seems that any bill which is less stringent than the Macau one may not be accepted by the PRC government. We suggest that all of these concerns against the Article 23 legislation is all about the lack of mutual trust. As to the meaning of trust, we refer to the trust and expectation that the government will operate in accordance with the concept of the rule of law. It is clear that the Hong Kong SAR government nowadays cannot meet the contemporary expectations of most of the Hong Kong people. The government's policies and its inability to resist the interference of the Chinese government have triggered strong public resistance in recent years. To rebuild the mutual trust, the Hong Kong SAR government needs to examine and advise the Chinese government that interference will only trigger more resistance. Apart from the government, it suggests that the institutions such as the prosecution, the Secretary for Justice, and the police have their role to play. It's vitally important for them to bear in mind the importance of staying politically neutral. Otherwise, it will further erode the trust between the public and the government. Finally, we have also discussed the uncertainty clouding the post-2047 constitutional arrangements. We are not sure whether one country, two systems is still applicable at that time. If not, we may consider to postpone the implementation of the Article 23 legislation. But if the one country, two system will sustain, we should implement the Article 23 sooner rather than later, as the society may be more politicized, and the Article 23 legislation at that time may be even harsher than now. Okay, so this is the summary of the part 2. Might
I suggest that some of the points just be more sharply indicated, like, for example, whether the law could be more liberal than that in Macau. One person raised that point. I think you could say that one person raised question about that, so that it doesn't look like it's our collective view. I think.
Yeah. I just want to emphasize that the notes and the recording, if we're going to publicize this, it's not going to be on an anonymous basis. So it will be the views will be attributed to individuals. So I don't think there's anything that we're going to do. Like, it's not a consensus or a collective.
Right. So
view.
Phrasing could be. So that doesn't show that. So on some of the points, you can say a concern was raised, or you can an individual, if you want to raise the concern of this nature, so that even though that's our view, others who read it, if it looks like all of us are expressing the view, might interpret it contrary to our intention. So just those points. I think there was two of them in the beginning you raised very soon. You could say concern was raised about this or that in that kind of phrasing, that it would be consistent with what we intend in that regard.
Yeah, I think you probably only used "we" because you're trying to summarize.
Yeah, because it's just a short summary, but we will do it not in an anonymous way.
Yeah, so the detailed notes, it's going to be.
Yeah, it will be more
detailed.
detailed.
Yeah, PY.
Yeah.
In the notes, I hear a Hong Kong/China dichotomy. This is incorrect. It should be SAR/Central Authorities dichotomy. Otherwise, we'll be accused of a very serious crime.
Okay.
Okay.
Carol.
There are some other items that we might want to add to the summary.
So can you take
One is there was some extensive discussion of the potential role of the NPC Standing Committee, whether it would be, if there would a potential reference from the Court of Final Appeal or a freestanding interpretation initiated by the NPC Standing Committee. It was even raised the possibility that someone might take a case to court complaining about the absence of legislation implementing Article 23. So I think we might just want to add that that was discussed. I think also Doreen Weisenhouse made some comments about the views of the media and the sense that the media was really very much under threat or felt under threat, particularly by Article 23. And because the media had been such a long time since the media felt that anything had been done to make their job easier as opposed to more difficult. And then finally, I think we did at least initially discuss, although we didn't really develop, the question of whether we should try to either address Article 23 very incrementally. I think Professor Lin supported that idea, or perhaps address Article 23 not only in the whole, but even linked to other potential reforms, such as creating a Human Rights Commission or creating greater democracy in Hong Kong to reassure people that the institutions that might be involved in enforcing this law would be better suited to protect civil liberties.
Reviewer, as suggested by Fiona.
Right.
Danny.
I'd just reiterate Carol's first point and maybe even flag it even more specifically, because, of course, we had quite an extensive discussion about the issue of possible standing committee interpretations, specifically in relation to references to the ICCPR in local legislation. So that really should be flagged.
Right. And Article 39 of the Basic Law.
Yeah.
Any other comments?
Then Julius.
Okay, our third one.
As for the last part, the center of the discussion is on China's interaction with Article 23 and the vulnerability of Hong Kong institutions. First, it was suggested that there has been a lot of changes in the political climate of both Hong Kong and China. In particular, there's a change of China's policy from peace maintenance to national security oriented. It is predicted that there will be more and more NGOs moving from China to Hong Kong, bringing along with them national security issues to Hong Kong. And there's a need to explore options in the absence of Article 23. There are two other main issues explored. First is the interaction between Chinese Criminal Code and Article 23. There's been a lot of extensive discussion on the issue of criminal jurisdiction and whether the Chinese Criminal Code can reach Hong Kong. And a lot of the discussions depends on the interpretation of that code. There have been a lot of issues raised on the reach of that code, for example, jurisdiction over land, jurisdiction over person, and it is also suggested that it also depends on the consequence and impact of that specific act to China. There's a lack of consensus about that effect of the Chinese Criminal Code. Further, there are some discussions about how enacting Article 23 will affect China's enforcing national security laws in Hong Kong. But this was not explored in depth, but some suspect that it will not stop China from enforcing their laws extrajurisdictionally, and incidents like Li Bo will continue to happen. The second main issue is institutions. Some suggested that courts in Hong Kong currently lack support meaning not only democratic support, but also strong traditions and legal culture. Some are pessimistic that a judiciary without the necessary support will sooner or later collapse because institutions are ultimately composed of individuals and relies on self-restraint, and are pessimistic about the future of Hong Kong's judges in upholding their rights protection duties. However, some have voiced disagreements and remains optimistic about the judiciary and that Hong Kong should make the most out of the pre-existing system. But it is agreed that there's a need to re-examine the strengths and weaknesses of Hong Kong's institutions. Last, some were curious as to whether China's broader policy on national security issues will change in the near future, but it seems that there will not be any major change given its top-down bureaucratic political structure.
Okay, is there further adding there, or additions, comments? Okay, so I think we're highly efficient here.
Any further points with wish list? Well, the point of this exercise is really, to gather views. Like, is there anything that you want the government to heed in the next consultation exercise, or want the Chinese government to heed? Any points that have not been covered in the previous discussion?
Not so much that, but I'd just say there wasn't really a consensus on whether there's a need to enact Article 23 legislation, was there? Yeah. Because Margaret's now left is very strongly opposed to doing so, and Carol and others put forward the rationale for doing so, and I don't think we reached a conclusion on that point, I think it'd be fair to say.
So maybe some comment at least about skepticism of doing it at all should be in the first session, yeah.
Yeah, I mean, and even I, although I can see some advantages to it, I'm not recommending it right now, particularly in the current political climate, so.
Yeah, it's left open.
Yeah, but there would be great reservations as to whether this is a good time, particularly because there is, I think, in the room, a fear among many of us that the government might take an even harsher approach to drafting and might not start with the revised bill, including the 3 concessions, might start with something harsher. As Dennis pointed out, the Macau legislation didn't include the 3 concessions, and so it's possible that they would not make those concessions any longer. So I think we're very much up in the air about whether it's a good time for Article 23.
Well, if I may, if there's a consensus at all, that's probably the issue of trust. The word trust came up so many times. I think, Albert and Surabhi.
What about the last question, which we didn't discuss? Because the last question is, are there legal consequences of not fulfilling the requirements of Article 23? So if this issue is postponed indefinitely, according to this question, maybe the issue will arise as to whether the NPCSC will apply some mainland law to Hong Kong. I think the mainland scholars have had have put forward such proposals.
Yeah, it's like how credible is that threat, basically? Yep, do you?
I don't know. I'm not familiar with the discussion in mainland, but I don't know whether
I think there's some views in the written submissions.
Professor.
I think Danny had some.
Other professors from mainland.
It did come up in Hualing's comments at the beginning when he made the point, which I also made in my submission, that even application of mainland law for Annex 3 would probably be pretty ineffective because it would be stated in such general principles. So that was the only time it was actually raised in the discussion, but we could be able to mention that.
But is there a possibility of applying more concrete mainland security law through Annex 3?
The only way would presumably be, so I did mention briefly in my submission, presumably if you identify a specific offence that is national security, I think Ming Tao mentioned that as well, you identify a specific national security offence which is not mentioned in Article 23, and then you argue Article 23 delegated power to enact on treason, subversion and so on, but it didn't mention this offence, and so you could apply. And I think there are other offences beyond those, or even though Article 23 covers the main ones.
Dr. Yan?
I just want to make some observation about the Chinese Criminal Code, add to Professor Huang's points. I think within the Chinese legal system, we just don't treat Hong Kong people as foreigner. We treat it as a PRC residents. But problem is we don't exclude every Hong Kong ordinance from the Chinese legal system, but we don't apply the whole mainland Chinese law in Hong Kong. We exclude the application of the whole Chinese law in Hong Kong. So I think Article 8 of the Chinese Criminal Law Code, it just treats different two categories. First is Chinese people, second one is foreigner. But I think Hong Kong people are within the Chinese people, but they don't apply the Chinese Criminal Law Code. That's the reason I think, in my own opinion, I don't think we will apply to Professor Tai. Even in mainland, we not apply the Chinese Criminal Law Code to him because he is a Hong Kong resident. So it's kind of privilege to the Hong Kong residents. I don't think we will treat Hong Kong residents as foreigners. It's impossible. It's different from the interpretation of the Chinese nationality law in 1996. But I think one way, if we want to add something in Hong Kong, there's one kind of way, just add the National Security Act in the Annex 3 and Annex 3 of the Basic Law through another way to apply the national security law. Is not make the Article 23 legislation, but apply Chinese law directly to Hong Kong, to add it in the Annex 3 or other way. Maybe it's more controversial, but so I think it is impossible to interpret the criminal law in China, because NPCSC also has power to interpret the Chinese law in China, make the legislative interpretation to make this apply in Hong Kong. But I think it is impossible, just in my own opinion.
Surabhi?
So this is a wish list issue, and it might seem a bit technical, but I think were there to be a law, I think it should address how minors would be dealt with to ensure that the leniency that exists for minors, the juvenile justice regime, continues to apply if someone who's not an adult is charged under any of the new crimes that might be created.
That's interesting. Anything else? We have 5 minutes.
Yeah, I just wanted to add maybe the point that Carol originally brought up in her I'm sorry, in her paper, and Margaret raised question about maybe the second panel should say something that there was skepticism about using the existing law, the existing 2003 proposed law, that as a starting point. So there was skepticism about that. Right, that it wasn't drafted with proper deliberation, and it was in a very difficult situation, and some suggestions about how to get started involving the Law Reform Commission as a vehicle for working on a draft. And I think it was the second panel where this would fit most.
Dennis, did you have a point?
Yeah, in terms of wish list, I think we all wish not the national law of China to be applied in Hong Kong. And for that purpose, perhaps we should try to see the Article 23 as well, not only about national security, but about the rights of people as well. Because if I'm a national of a country and treason, theft of state secrets and so on take place, they affect me as well. And then if we see this article as a way also, or within the system of Hong Kong of safeguarding freedoms and rights, then maybe this is out of the competence of China. And then we can find many articles here, including the preamble of the Basic Law of Hong Kong, saying that the system to safeguard the rights and freedoms of Hong Kong, it's up to Hong Kong. So if we read this Article 23 also as protecting rights of people of China and Hong Kong, so it's within our competence. But in any case, just perhaps to add there that we somehow, I think it's not desirable to have the law of China in any form, in any way in Hong Kong.
Yeah,
Can I just respond quickly? And it is important to note that Article 23 does have those words, shall enact laws on its own, which I would argue would make it a real stretch to apply national law through Annex 3 to a topic that is expressly given to the local government.
Yeah, so I think the third panel has to say that there was a lot of skepticism about any addition of mainland security laws to Annex 3, that the view widely shared was that Hong Kong is to enact its laws in this regard on its own as provided in the Basic Law. So very precisely.
Yeah.
But we had a lot of discussion, and I think a colleague just brought up the point that, it would be difficult to apply the mainland law, in fact, under the common law in Hong Kong.
Well, one possible view raised by Danny in the written submissions was that national security crimes that are not covered by Article 23 arguably.
You can draw a distinction, and I think Dr. Huang made it simple. You can draw a distinction between general principles on national security and specific offences. I'm happy to be shot down on that, but the point was that we never actually really got to that in the last discussion, just because we had so many other issues to deal with.
Ming Tao.
Well, actually, my comments are in my written submissions that actually about the national security law that passed last year in Beijing. I think technically or politically, I think MPCS will not add that law to the Annex 3 of Basic Law because that law is so general. It's about the abstract policy. I think that law is trying to provide some ground for systematic institutions about how to maintain the national security. And we have to know that the concept of national security in that law is not only a crime. It's got a broader concept, anything related to national security. So we could economic security, nuclear security, environmental security, cultural security. So this is a whole, I call it a wholesale concept that try to cover everything. So it's way beyond a criminal law. So I think it's unimaginable to see that being added to the Annex 3 of the Basic Law. But I think as the normal practice, the legislative practice in mainland, there will be some specific
legislations, or maybe some regulations, some delegated legislations to implement that law. So, but maybe that specific legislation will not done by the NPCC, maybe by some delegated bodies like some executive branch. So in that kind of situation, I think we need maybe another conference to talk about that, the technical problems.
Yeah.
But I don't see the possibility now.
I have one final point, can I? So back to the point about institutions. I think we talked about how the point that the problem is perhaps not with the legislation, but with the evidence for prosecution and adjudication. And that evidence might come from mainland authorities. If they issue a certificate or a letter or something, then it would be highly persuasive or binding on Hong Kong institutions, and that would be the connecting door to import mainland concepts of security. We haven't got to this, but I think it will be very useful if we're to think about Article 23 legislation as to institutionally, or in terms of drafting, is there anything we could do to not stop this from happening, but having Hong Kong in control of this evidence rather than taking evidence entirely from, or relying entirely on mainland institutions for this evidence. No matter how well the legislation is drafted, if when it comes to whether X is a terrorist, you need to rely on a mainland judgment. It does not matter what the legislation, it's a factual question. Well, but we didn't discuss, is there a solution? But we're not here for the solutions. We're here to identify problems. Yeah, well, we discussed what the problems are. So I think it would be useful to think about what the solution might be. Is there anything we could do in the drafting or in terms of the setup of the institutions that could solve this? And the other point is in terms of the personnel that runs the institutions, the point that Simon has raised. I think Margaret and Simon have made the point very clearly that we need personnel who are strong in defending Hong Kong's autonomy and our fundamental values. So courts, are they going to be increasingly deferential on national security matters? Prosecution authorities, our chief executive, whether they're going to really stand for Hong Kong people's interests. That's, in a way, it's the self-discipline of Hong Kong people. But in terms of institutional setup, is there anything that could be more conducive to the production of this culture? Democracy is perhaps the necessary.
I think you're talking about the integrity of the Hong Kong system, that whatever's done in this area, that the integrity be maintained in the mainland system, not imported into it. Yeah.
And a vibrant civil society, the point that Margaret has been, vibrant legal profession.
Yeah, these are the hedges. Again, in fact, that's what the Occupy movement was, in my view, is trying to maintain Hong Kong's autonomy and rule of law. Yeah.
Anything else? No?
Yeah, it's good.
We should definitely get these views out there. Preliminarily, is there anything in the recording, do you think it is problematic and we want redacted or can't be released?
For Benny, you should decide whether you want such extensive discussion of your criminal consequences of your action. That's not for us to decide, but that would strike me.
He's an optimist.
Belatedly, I would like us to thank Cora for organizing this and her colleague in the back for working on that as well. Can we give them a hand?
Thank you very much, Michael. A special thanks, students, very well reports, very accurate reports. A special thanks to the co-chairs, Carol, Michael, Simon, Hualing, and to our overseas guests, Fiona, Imtiaz, Dennis, Mingtao, and Carol, Michael. So we will be sending around the written notes and the recording for your editing and comments. We would probably reconvene this group. Well, hopefully not. Hopefully no need to reconvene this group, but we might reconvene this group at some point.
I hope I can speak for Carol and say we're always happy to be reconvened in Hong
Well,
Kong.
these views would be tremendously helpful for the next consultation exercise. Yes, Simon.
If we do reconvene, and one thing that we really didn't explore is because we operated on the premise that we need new legislation, right? If we do reconvene, I'd be fascinated to see what the analysis of the existing law is and how it could be adapted to deal with things, because that's an issue that would really put a lot of pressure on the courts. I mean, if you have an executive that's prepared to use the existing law to deal with the independence movement, future Occupy, how could the existing law be interpreted? And the same issues will arise again. Will there be an MPCSC possible interpretation?
I specifically make that point in my written submission, first set of written submission.
Sorry?
I specifically make this point on my first set of written submissions on what's the approach, adaptation or incorporation, and if we do adaptation, government should state the position on what the modifications are, and also then we can apply the modified existing law to the jurisprudence and see what's happening to many.
Yeah, thank you. Well, deeply felt thank you on behalf of the CCPL and the Faculty of Law for your very fine contributions. We'll advertise this event and the proceedings. We'll duly do that. We'll make sure that these views are not wasted and that they will reach the audience. Thank you, Mr. Mu. Thank you, Ms. Xu, for being in the audience. We hope that we're of some help. So wishing you all the best and good luck to Hong Kong.
Dinner or something you have
Yes.
to explain?
So some of us will be taking our guests to dinner. So there will be a van. Is there a van waiting? Yeah, there will be a van waiting for us at LG1. So let's stay in this room for those of us who are taking the guests to dinner. Okay, thank you.
Thank you, Cora. Such a good